Welcome back to the RG Limited boardroom. Adjust your lighting and pour yourself a glass of something that has aged significantly better than this legal battle because today we're diving into a 12-year telecommunications standoff that is a masterclass in how to turn a $9 million claim into a procedural nightmare. We are looking at the saga of Betam Communication Tanzania Ltd and China International Telecommunication Construction Corporation, CITCC. This isn't just a dispute over a contract. It's a lesson in why the fine print and court fees can be more dangerous than the actual opposition. Here is your high society briefing on the 12-year telecom trap, served with the signature Oksana Rabbit's edge. The scene: the $9.5 million stake. Back in 2012, Betam Communication marched into the High Court claiming United States dollars 9,541,926.97 for commissions, interests, and damages. In our circle, darling, that is legacy money. But instead of a swift trial, they entered a legal labyrinth that could last over a decade. Maneuver number one: the automatic right myth. The first major clash happened in 2014. The court ordered Betam to fix a tiny technicality, to attach a board resolution to their paperwork. The defendants, CITCC, thought this was their opening. They filed entirely new, quote, amended written statements of defense without asking the court for permission, essentially trying to rewrite the strategy midstream. The boardroom verdict. The judge, Honorable J.H.K. Utamwa, wasn't having it. He ruled that while you can fix a typo, you cannot, quote, ambush justice by introducing new defenses without leave of the court. In the RG Limited boardroom, we know that if you don't get permission to change the deal, the original deal stays on the table. Maneuver number two: the piecemeal delay. CITCC then tried to kill the case by arguing that the court couldn't handle a claim in US dollars. The judge dismantled this, noting that in modern Tanzania, foreign exchange claims are perfectly legal. But more importantly, the judge called out their, quote, hidden agenda. They were raising legal objections by installments, one by one, just to keep the case from ever being heard. The judge ruled that this style of, quote, piecemeal litigation is an abuse of court process and a violation of the constitutional right to a speedy trial. Maneuver number three: the 20,000 shilling heartbreak. Just when Betam thought they were heading for a win, the case almost died because of 20,000 shillings. In 2020, a trial judge realized that Betam hadn't paid the mandatory 20,000 exhibit fee, shillings I mean, for 10 crucial documents. Without even hearing Betam's side, the judge basically ignored the evidence and ruled against them. It took an appeal to the Court of Appeal to remind everyone that even a, quote, rule breaker has a right to be heard before you throw their case in the bin. The 2024 Reset Retrospective Reality. By 2024, Betam argued that since the exhibit fee law had been revoked in 2018, they should be off the hook. But the court's latest ruling, delivered in May 2024, dropped a truth bomb. Procedural laws might be retrospective, but they aren't magic. Since the case was decided before the law changed, they still owed the money from the old regime. The outcome. For the sake of, quote, fairness and the, quote, interest of justice, the court finally gave them 7 days to pay those tiny fees so a fresh judgment could be written. 12 years of fighting, all for a fee that costs less than a decent lunch in Dar es Salaam. The court's decision in the May of 2024 ruling of Betam Communication Tanzania Ltd and Citcc hinges on a specific interpretation of how changes in procedural law affect ongoing or revisited litigation. While Betam argued that the 2018 revocation of exhibit fees should apply to them, the court clarified the strict boundaries of legal retrospectivity. The background, the 20,000 shilling technicality. During the original trial, Betam submitted 10 key exhibits, P1 to P10, under the court fee rules of 2015, GN number 187 of 2015, which were in effect at the time. The fee of 20,000 shillings was required for each exhibit tendered in the High Court. Betam failed to pay these fees, leading the original trial judge to ignore that evidence and rule against them. A decision the Court of Appeal later nullified because Betam hadn't been given a chance to be heard on the matter. Secondly, Betam's argument, retrospectivity as a shield. By the time the case returned to the High Court in 2024, the law has changed. The court fees rules of 2018, GN number 247 of 2018, had revoked the 2015 rules and removed the obligation to pay for individual exhibits. Betam's legal team argued that procedural law is retrospective, unlike substantive laws which affect rights. Procedural laws which affect how a case is run generally apply to past actions. The law of the day. Since the 2015 rules no longer existed, they claimed the court could not legally collect a fee that was, quote, no longer part of government revenue. The court's truth bomb. Why procedures aren't magic. Justice Ngunyale agreed that procedural laws can act retrospectively, but he established a critical, quote, cutoff point based on when the original legal act occurred. The timing trap. The court noted that the new 2018 rules came into operation on June 1st, 2018. However, Betam's original hearing had already concluded, and the first judgment had been delivered on March 27, 2017. Vesting of the obligation. Because the exhibits were tendered and the case decided before the 2018 rules existed, the obligation to pay under the 2015 rules had already, quote, vested. Preventing procedural chaos. The court adopted the defendant's warning that allowing retrospectivity in this case would invite, quote, chaos in the administration of justice. It would allow any party whose case was struck out years ago to demand a do-over simply because a fee or rule was later amended. The final resolution? The court ruled that the relevant rules remained the old 2015 rules because they were the law of the land when the trial actually took place. Consequently, the order. Betam was ordered to pay the fees for all 10 exhibits, P1 to P10, according to the 2015 rates. The deadline. They were given 7 days to settle the debt. The progression. Only after these old regime fees are paid will the court proceed to write a fresh judgment based on those exhibits as ordered by the Court of Appeal. The Oksana Rabbit's final take. Darlings, the lesson from the Betam and Citcc files is simple. Don't let the maid of justice procedure become her ravisher. Pay the small bills. If the court requires a 20,000 shilling fee, pay it immediately. Don't let a $8 technicality steal a $9 million empire. No piecemeal plays. If you have an objection, throw the whole book at them at once. Judges have no patience for, quote, installments of drama. Written is king. An oral agreement can never override a written contract. If it's not in the ink, it's not in the bank. Now, if you'll excuse me, I need to go ensure my own administrative fees are paid through 2030. I don't do, quote, derailed by exhibits.